Hello, my people. Welcome to Legal Connect. Welcome to this space, the space where we talk about legal issues that is affecting Nigeria and Nigerians. I hope you've had a good few weeks since the last episode, and today we are dealing with a new area of interest. We have seen how the President Ahmed Bola Tinubu has kicked off his campaign or his premiership as the next president of this country. I will say that I am surprised. However, I have not seen anything substantial that has happened since he took the oath of office. I've read and I've heard and I've seen people saying that, his government is working. I don't see anything that is working yet. He seems to be busy. Aso Rock tend to become a very trafficked area now. People going and coming, all sort of Nigerians going to go and see the president. Probably I will put in my own application to go and see him as well, in order to have an audience with him. But irrespective of that, it is good to have life in the country again, taking into consideration the days of the former president Buhari, whereby he neither say nor acknowledge anything, but at least President Tinubu is seen to be very active. We've seen that in the last few days, Mr. Godwin Emefiele, he's gone, and EFCC chairman, he's gone as well. I am concerned in the sense that I don't want them to be locked up and the key thrown away or their human rights violated, irrespective of the fact that they've committed any crime or they've omitted to have done something. I want this process to be transparent. I want the president to make sure that the DSS upholds the fundamental human rights of these men, especially Mr. Emefiele, because there has been rumors that he wasn't arrested by DSS or he has been arrested by DSS. I want the DSS to come clean, avail him the opportunity to speak to his lawyers if the law permits, and only detain him up until the law permits. Don't unlawfully hold this man. If he has committed a crime, then we should be seeing you taking him to court and put him on the dock and read the charges to him so that he will be tried. He will have a fair trial in this process. So I implore Mr. President Bola Ahmed Tinubu, if your government is actually changed or is going to distance itself from the past administration, then you should be seen upholding the rule of law and the fundamental human rights of every Nigerian, including Mr. Godwin Emefiele and also the EFCC chairperson or chairman. But that is not what we're going to talk about today. We are going to look at the Student Loan Access to Higher Education Act 2023. I'm going to analyze content of this act, and in my opinion, it's not worth the paper it is written on. However, if you think that I have got it totally wrong, please leave your comment. Let's have a debate. If you think that this act, the Students Loans Access to Higher Education Act, is worth it says it is, and that is going to provide access to the Nigerians that are deprived of higher education, please leave your comment and let's have a meaningful debate. However, before I go in there, I just want to encourage Nigerians that don't jump or don't start running before you learn to walk. Why have I said this? President Bola Ahmed Tinubu's premiership is less than a month old. People are already congratulating him that he's achieved something or that he's working. Don't go ahead of yourself. He hasn't achieved anything. The subsidy remover, he didn't remove the subsidy. He told us that it's been removed, that the budget that was prepared, that there was nothing, no provision for subsidy. So he implemented the removal of subsidy by the previous administration. And the fact that we've been told that subsidy has been removed, we really don't understand the concept of this whole subsidy, because the subsidy has been removed. There are people arguing that there was never a subsidy, that this country was being bled on the premise of subsidy. So we need clarification. We need understanding of this whole concept of subsidy before we start thanking and praising President Bola Ahmed Tinubu that he's done well with this subsidy removal. And also, as I've just said, he's less than a month old. You shouldn't be running and saying that he's done something. There is still hardship in the country. From what I've seen, it seems that he's going the right direction. He's like a bulldog, a toothless bulldog. He's making all the noises, which is good. But I want him to start sticking his teeth into policies, into behaviors of government. The way I'm saying it, there is a lot of noise going about. Mr. Asari Dokubo, former militant, have made accusations to the military, has made accusations to the Navy. This is not something that we should sweep under the carpet. It should be investigated for us to have understanding if those people are actually involved in bleeding Nigeria of its natural resources. All these pockets of allegations need to be looked at, and it should be looked at in line with the provisions of the Constitution, in line with the fundamental human right of every Nigerian, not just rushing into it, lock people up. After 6 months, everybody forgets about them, and then they go about their normal life. So please, Mr. President, settle down. There is no rush. You've got 4 years. You don't have to do everything in 2 weeks. You've got 4 years. As far as we Nigerians see that you're on the right track, take your time. Make sure that when you decide to prosecute, you know that you have substantial evidence to show that someone that you're prosecuting is guilty beyond reasonable doubt. I don't want a situation where these government agencies rush into things, and at the end of the day, it gets kicked into appeals upon appeals upon appeals until they just take out the life out of the process. So let us tune to today's episode. Before I start looking at this episode, I just want to encourage my listeners, my viewers, hit that subscribe button. I want you to be part of this whole debate, looking at the legal affairs that affect Nigerians and Nigeria. I want you to provide comments. I want you to challenge me if you want to. Let's have a meaningful and reasonable discussion or a debate. Let's put our heads together. Hit that subscribe button and be part of this space. So, the Students' Loan Access to Higher Education Act 2023. This act was prepared by the Ninth Assembly, but was not signed into law during the administration of former President Muhammadu Buhari. And so the new President Bola Ahmed Tinubu, signed this bill to become law, to become an act of parliament. The Student Loans Access to Education Act 2023 actually have 23 sections, which includes the definition, the interpretation, and the citation. I may not be able to go through the 23 sections, but I'm going to try and pick out those sections that I think doesn't make sense or is just absolutely garbage, should not even find itself within the content of this act. The first section, section 1, says, notwithstanding the provisions of any act, enactment, or law, this act shall apply to all matters pertaining to the application and grant of loans to Nigerians seeking higher education into institution of higher learning in Nigeria through Nigerian Education Loan Fund. Section 2 says, subject to the provisions of any other enactment, all students seeking higher education in any public institution of higher learning in Nigeria shall have equal right, mark the word equal right, to access the loan under this act without any discrimination arising from gender, religion, tribe, position, or disability of any kind. This section that talked about equal right is very, very important. However, I will say, or I will argue, that this section contradicts most of the provisions of this act. And then you move to section 3. The loans referred to in this act shall be granted to students only for the payment of tuition fees. So which means that the money that a student is going to get as a result of this act is for the tuition. What about the maintenance? What about upkeep? Loans for tuition alone is nothing compared to the expenses of actually being a student. People that have gone through the university education will notice that the tuition fee is very, very low compared to the amount you spend each year taking care of yourself. How can you provide loans for tuition but nothing for maintenance or upkeep? I will argue and submit that the government should have thought about granting at least a minimum grant or even a loan for the student upkeep, because at the end of the day the student is going to pay it back. What's the point of giving them loan to pay for their tuition and nothing for them to live on? How will the student concentrate on education if they've paid their tuition but they cannot pay for rent or even feeding money? So the parents now will have to go and look for those money. How do you then achieve the heading of this act, student loans, access to higher education? Access to higher education is making a student comfortable that all they think about is the education that they are getting. Because the student paying for their tuition doesn't take away the worry of how will I get the money for my rent? How will I get the money for my upkeep? How will I get the money for textbooks, for other things? So there are other payments within the education that they have to take care of, not just the tuition. Section 4 says, the grant of the loan to any student under this act shall be subject to the students or applicants satisfying the requirements and conditions set out under this act. So how does this collate to section 2, which says that every student, every person shall have equal right to access the loan if they are subject to requirements and conditions? So let's see what the requirements are. Under section 14, it tells you what are the requirements. Section 14, students applying for loan under this act must apply as provided under section 17 of this act on satisfaction on the following conditions. Applicant must have secured admission into any of the Nigerian university, polytechnics, colleges of education, or any vocational school established by the federal government or the government of any state of the federation. Section 14b, applicant's income or family income must be less than 500,000 naira per annum. I think having a maximum of 500,000 per annum or less qualification is repugnant. I think that this amount should be increased to must not be less than 1 million naira per annum rather than 500,000 per annum, given the fact that an applicant could have both parents working. Applicant must provide at least 2 guarantors, and each of the guarantor shall be a civil servant, at least level 12 in the service, lawyer with at least 10 years post-call experience, judicial officer, or justice of the peace. This is where the sticky bit that irritates me is situated. Applicant must provide at least 2 guarantors. First of all, what is a guarantor? I don't know if the lawmakers understand the word guarantor. A guarantor is somebody that confirms, stating that I would be responsible for this person's loan in case if that person defaults or did not pay the loan. I will be held liable to pay that loan. Basically, what the government is doing is that the guarantor will be the police that will make sure or ensure the applicant pays the money back to the government. And if the applicant fails, the guarantor now will be held liable. Okay, let's take for instance, I as a lawyer, why will I want to sign to be a guarantor for someone I don't know? Because the person just walked into my chambers and said, I need a guarantor for me to apply for a student loan. And then I would just meticulously pick up my pen and say, where is the section for me to sign? Does that actually make sense? That I will vouch for someone that I don't know? Or does the government expect every applicant to have either a civil servant at level 12 grade, a lawyer with 10 years post-call experience, judicial officer or justice of peace? Every applicant must have this in their family. And more so, I, for instance, as a lawyer, am I going to provide this service free of charge? Or am I going to charge this applicant in order to be a guarantor? Guarantors are always somebody that knows you. Guarantors are people that are close to you, that can be able to assess you, that can be able to pay in lieu of you paying. But why would a lawyer that doesn't know an applicant sign that they are guaranteeing that the applicant will pay? And if the applicant doesn't pay, they will be responsible for the loan. And the loan is not 2 weeks time, it's not a month time, it's not a year time. It's probably, if it's a 4 years course, 4 years. And if you go by the behavior of universities or universities lecturer, going for a 4 years course, you might end up spending 8 years. I, as a guarantor, will be in limbo for the next 8 years with the fear that this, not even 8 years, until the loan is paid back, I will be cautious. I will be in a fear that what if this applicant doesn't pay back? And how many applicants do I have to guarantee or stand as a guarantor for? How many applicants? In this scenario, you see one of these officers standing as a guarantor for 10 people without no knowledge if these people are going to be able to pay this money back in 4 or 5 years or 6 years time. And then this is an avenue of business for these officers because they are not going to provide this service for free. Why would they need a guarantor? Their parents is enough guarantor, in my opinion. The fact that their parents gave birth to them, their parents know them more. Their parents should stand as a guarantor for these people. That should be enough. That's why you are mean testing them. You want their parents to earn nothing more than 500,000 naira. So why then do you still need a guarantor that doesn't know these people? Even if they know them. Is it going to be a brother? If it's an uncle, I doubt if an uncle will vouch for a nephew and a niece to be a guarantor for them in the next 10-15 years. So this section 4C, I think it is wrong. The section 4C is not required in this act at all. There should be no guarantor. Not even one guarantor should be required, let alone two guarantors. This is a surmountable condition that this applicant will not be able to meet. The next section, section 15, a student is disqualified from accessing the loan if he is proven to have defaulted in respect of any previous loan granted by any organization. And you said that this is an access for students to get higher education. This is an opportunity for every student to have equal rights. The fact that they defaulted in other loan should not be a criteria for them to be deprived of this loan. Rather, you should treat each case by case. You should not have a blanket condition, but you should deal with each case by case. I think the paramount condition should be that they have a university admission and their parents stands as a guarantor, or their parents, you check the income their parents earns in order to decide if they are eligible or not. So it should be a blanket eligibility for Nigerian public universities, and then look at case by case the condition of each applicant. 15B, he has been found guilty of exam malpractice by any school authority. That is subjective, because how can you be relying on the tertiary institution in order to determine if they can access this loan? What if they've been picked on, that they've been lied against? Now you've deprived them of the opportunity of accessing the loan. 15C, he is convicted of a felony or any offense involving dishonesty or fraud. That is fine, I will allow that. He has been convicted of drug offenses. I will allow that, but what type of drug are we talking about? E, any of the parents has defaulted in respect of student loan or any loan granted to the person. We're talking about, I don't actually see the relevance of this section E, because the parents are not the ones that will be defaulting in the payment of student loan. It is the applicant, not the parent. So why is it that any of the parents has defaulted in respect of student loan or any loan granted to the person? It's confusing. If the parents have defaulted in loans that they've taken on their own accord, that should not be a reason for their son or their daughter to be deprived of a loan, because the loan is going to the student, not the parents. So the fact that the parents has defaulted in the past doesn't be a reason to deprive the son or the daughter the benefit of going to getting a loan for higher institution or for the university studies. So I don't quite understand the reason for this E, because the student, the applicant, has a separate life to his or her parents. The sins of the father or the mother should not be visited on the children. 16, subsection 1. All application must be submitted through the applicant's bank to the chairman of the committee established under this act, accompanied by a cover letter signed by the vice chancellor or rector or the head of the institution and the student affairs officer of the institute. That is preposterous, in my opinion. Well, these are conditions that this applicant will not be able to meet. You want to give them loan, not covering every aspect of their education, just the tuition, and you put in these rigorous conditions that at the end of the day the student will be frustrated and then miss out on the loan. First of all, you have to submit the application through your bank, and this service is not going to be free. I don't want to compare the process of student loan with other countries, especially the Western world. But this is ridiculous that you have to submit in the bank. I don't know if it's going to be free. It doesn't say here that the service is going to be free, and I believe the bank is going to charge for the service. Why put a burden on these students, for crying out loud? Why put a burden on these applicants? This process is supposed to be free, fair, and easy. But all what we've read shows that it is not a process that I will want to engage in for just to get a loan that I'm going to repay back. It's not free to pay for my tuition. Whereas I've still got other bills to take care of outside of the tuition fee. Why do you have to go to the bank? Why do you have to get a cover letter? An application should just be an application. The application should have the applicant's details. It's a form. You don't need a cover letter. Dear sir, I'm writing to apply for student loan. The form is there to show that I am applying for student loan. I don't need a cover letter to show that. Why should the cover letter be signed by the vice chancellor? The fact that I've been given an admission, the process should just be as simple. Submit your application. The committee or whatever that they've set up, which we're going to look at in the next few minutes, you write to the school to confirm that this student has an admission. The student should not be the one chasing a vice chancellor for the signature or chasing a rector and then the student affairs for signatures. The process should be, once you've gained an admission, fill up your form, put the name of your university, the committee or whatever it is, contact the school for confirmation. Has this student been granted admission? Yes, he has been granted admission. And you stamp it. Accepted. That is it. You don't need a rigorous process. Each application shall be accompanied by a copy of the student's admission letter, a letter by the guarantor addressed to the chairman of the committee established under this act, recommending the student for the loan and stating that he accepts liability in the event of default. Why will I, a lawyer, sign that I'm going to have responsibility or liability for a random person that I don't know before because the person walked into my chambers? Do they actually think? Even sometimes a relative will not sign as a guarantor. I won't sign as a guarantor for my niece. I won't sign as a guarantor for my nephew, because it is a burden. So the danger of this is that they've said you pay back 2 years after youth service. So it means that after 2 years after youth service, they don't get a job. By default, the guarantor automatically start paying until they get a job. So if in the next 5-10 years after the youth service they don't get a job, the guarantor definitely will take responsibility. Even that is a problem. It's supposed to be the case that the student will be liable. There should be a system where you're able to track down students through their name or whatever it is that that is associated with the bank. You don't pay cash in hand. Every salaries have to go through the bank. Even if you're self-employed, you have to have a business account. That is what the country is supposed to be doing. So you can trace these people, the name and everything. You collaborate with all the banks that these are the names that you should trigger up once they start getting money. The guarantor should not be taken, because at the end of the day, once the guarantor signs that application form, the very day, the very minute that the guarantor signs that application form, the guarantor is already liable to pay, because there's no guarantee that the applicant 2 years after youth service is going to get a job. So automatically, once the date that the 2 years complete, the next day the guarantor start paying. That is the provisions of this act. And who, in its right sense of reasoning, will want to sign as a guarantor when you know that once the student finishes their youth service 2 years after, you are going to be liable? I wouldn't put my name to that form. No matter how much you pay me, up front. I'm not going to put my name to that form. So let's continue. 2 passport photograph from each of the guarantor, name of employer, and evidence of being so employed by the named organization. Particulars of guarantor's business registration with the Corporate Affairs Commission or any other appropriate authority, and his bankers where the guarantor is self-employed. The committee shall communicate to the applicant on the status of his application within 14 days of the receipt of the application. Disbursement shall be on availability of fund. Even look at, you can even apply, you might not get the money because it said it's availability of fund. They can come back tomorrow, we don't have money. Basically, preposterous. Okay, let's look at the committee. Let's go back and look at the committee. Section 7, that's where the committee is created. There shall be for the fund a special committee in this act referred to as the committee, which shall be responsible for the performance of the functions of the fund. The committee shall consist of the governor of the Central Bank of Nigeria as the chairman. What if the governor is a woman? That's sexist to say chairman. A chairperson should say. The secretary of the fund, who shall be appointed by the chairman. The minister responsible for education. The chairman, National Universities Commission. A representative of Vice Chancellors Forum of all Nigerian universities. A representative of the Rectors Forum of all Nigerian polytechnics and Provost Forum of all colleges of education in Nigeria. The minister responsible for finance or his representative, the auditor general for the federation, a representative of the Nigerian Labour Congress, a representative of the Nigerian Bar Association, and a representative of the Academic Staff Union of Universities. Okay, what are these people actually going to be doing? What does the Nigerian Bar Association representative doing there? What is the Academic Staff of Union of University doing there? What is the Vice Chancellor's Forum doing there? All these names that all these big names that they've mentioned, what are they doing? Are they going to sift through each form one after the other? Why don't you just create an office, create a sector where the employees of that sector can actually administer this process? Why would the Central Bank of Nigeria, the governor of the Central Bank of Nigeria, who have been earmarked to be continuously to be a man because it says a chairman, he's supposed to be a chairperson. We can have a woman central bank governor. Has he not got enough on his plate by saddling him with this responsibility? And there is nowhere it is defined what these individuals are going to be doing. What is their role? Is it sipping through the application form? I think there needs to be clarity as to what these individuals are actually doing within this committee, because they have responsibilities already. Just create a government establishment, create another department that falls within the Department of Education to oversee this process. They are answerable to a minister of Education. You don't need these lists, you don't need these persons in order to carry out this function of giving whatever you call it. Is it student loan? It's not loan. It's not student loan. Because if it's student loan, every student should be entitled to it. They've whittled it down that it's only few students that will get it at the end of the day, after they must have gone through the pain, the hardship of getting someone to be a guarantor. Because those that will end up having access to the list of guarantors will be kids of rich parents and then they are not even eligible, because those that are eligible, their parents cannot get a guarantor. Those that can get a guarantor, their parents are earning more than 500,000. So that is the dilemma that these students are going to find themselves in. Guys, I would have loved to continue because it's quite interesting what actually enacted. I wonder if these legislators actually read the content of what they've signed into law, especially Mr. Tinubu. I don't think he read the content or sought an advice on this document, because the document is useless. It doesn't help gain access to education by the students, because the conditions that they are required to fulfill is unfulfillable, in my opinion. They can't fulfill these conditions. A majority cannot fulfill this condition. I would never be a guarantor for someone that I don't even, there's no assurance they're going to get a job in 2 years after youth service, which means I'm going to be saddled with that debt. So why will I want to sign for someone especially people that I don't know? They've given these people so high condition that I don't think they're going to make it. Hopefully, we'll look more into this act in subsequent episode. I believe at some point we'll look more in details to other areas of this act that I just think that it is absolutely useless. What is my recommendation? This act should be repealed. Repealed and amendment introduced. If you want to make life easy for the less privileged, make it easy for them. You shouldn't give them the responsibility of making sure that they pay back loan. You shouldn't put burden on their guarantor. They shouldn't even have a guarantor. It's even better, in my opinion, that the parents are guarantor than for a random person to be by guarantor. Because if you start chasing the parents, the applicant, if they have a job, there's no guarantee that they're going to get a job. The applicant will have that sympathy towards his or her parents and then look to start paying back the loan. However, a guarantor that you don't know, probably you've paid to be a guarantor, will end up taking up your debt, and then you don't care because you don't know the person. Whether the person pays or not, that's left for the person. So guys, I hope you've enjoyed my analysis of the few sections of this act. If you think that all that I've said or that I've talked about, my opinion is garbage, leave a comment. Let's have an informed discussion. If you think that this is a brilliant piece of act, leave your comment. Otherwise, if you haven't subscribed yet, click the button and subscribe to join this forum so that you get notification as of when we post new materials. I hope you've enjoyed this episode from Legal Connect, and I hope to see you next time with new area to look at, either continuation of this act or look totally at a different area of the law in Nigeria. Have a wonderful day and take care now. Bye bye.